Thank you very much, and congratulations for organizing this very important event. I think this is really timely, and thank you very much also for inviting me to give this keynote address. I'm very honored, although sad not to be with you in Nuremberg today, and I hope there will be other opportunities to meet you in presence. So in the following 30 to 40 minutes, I would like to report a very interesting story that I have heard from an investigative journalist working on mob activities in Europe and in the world. I won't mention the name of the journalist, who is currently under a witness protection program, but the report speaks of two persons. It happens that those two persons have the same initials, ED. Of course, we won't call them by their real name. You will understand why in a minute. So we will use these initials, ED. But in order to be sure who we are speaking about and not to mix the two, we will identify each of the protagonists by their city of residence, Geneva and Rome. So let's say we have on the one side ED Geneva and on the other side ED Rome. Now let's introduce those two persons. ED Geneva is the head of the World Organization of Oppressive States, WOOS, the WOOS. Of course, you can imagine this is not an official organization, but rather an underground organization. But the members of that organization are themselves quite official. They are mostly high command officers of security services of a number of states around the world. Some are even head of states or head of governments. The states to which they belong may be allies or enemies. It doesn't really matter. WOO's aim is cooperation in the field of oppression and repression. They exchange good practices and information of all sorts. They may also cooperate to eliminate opponents across the world. A sort of Plan Condor extended to the world, if you will. ED Rome is also heading a very important worldwide organization, the Criminals Organized Global Union, COGUN. Neither this is an official organization, and the members are most unofficial, as you may think of. They are all heads of criminal organizations around the world, dealing with all sorts of traffic, drugs, of course, human trafficking, weapons, but also smuggling of migrants, etc. So now you know the characters. ED Geneva from WOOS, ED Rome from COGUN. Both ED Rome and ED Geneva are heading to an international congress on crimes against humanity in The Hague, where they will feature as key speakers. On their way, they have agreed to hold a private, informal bilateral working meeting in Nuremberg. They often go there to meditate where the Nazi Nuremberg rally took place and get inspiration for their own activities. The meeting takes place in a meeting room of a fancy but not too fancy hotel, not too far from the Nuremberg Palace of Justice. And the topic of the meeting is, and I quote, "good practices in enjoying impunity from enforced disappearances." So here is the report, the transcription of the dialogue. "I am anxious," starts ED Rome with a frown. "In Rome, something bad has happened. The Rome Statute of the International Criminal Court has entered into force. It sets up an international court in charge of prosecuting genocide, crimes against humanity, and war crimes, and even aggression at some point. Can you imagine? And guess what? Enforced disappearances are included in the list of crimes against humanity. And guess what's more? Those people who drafted the statute thought it would be smart to provide that enforced disappearances could be prosecuted when perpetrated not only by a state or state-sponsored group, but also by, and I quote, political organization. That you can read in plain letter in Article 7, paragraph 2I of the statute. And I quote, enforced disappearance of person means the arrest, detention, or abduction of persons by or with the authorization, support, or acquiescence of a state or a political organization. I thought Kogan members would get crazy when they get to know that. We are targeted. Oh, just don't mention it, replies E.D. Geneva from Woos. This is awful. But in Geneva, things got even worse. As if it was not sufficient to have a declaration on enforced disappearances adopted in 1992, and even a working group dating back from 1981, since 2010, we also have a convention and a so-called committee of experts on our back. Woos did everything it could to avoid that, but it did not win this time. Fortunately, only those states that have ratified are bound. So for us, who keep on the good practices, this is just about avoiding ratifying the treaty. Not so easy sometimes, though. Some states and even NGOs put pressure on us, infringing on our sacred sovereignty. Aren't we free after all? Yes, you are, interrupts E.D. Rome. And that's what makes you so useful to us sometimes. Trafficking under the veil of sovereignty is the best place under the sun. Still, yes, I envy you. Your Geneva Convention is not as bad as our statute. It only covers your people, including those who are working undercover, but still, it does not reach to the good old criminal organizations. Well, says E.D. Geneva with a grin, I would not be so sure, you see. It's true that the definition of enforced disappearances as provided in Article 2 includes a state agency element, that is, enforced disappearances must be perpetrated either by a state agent or with the authorization, support, or acquiescence of the state. But Article 3 of the Convention also provides that, and I quote, each state party shall take appropriate measures to investigate acts defined in Article 2, committed by persons or a group of persons acting without the authorization, support, or acquiescence of the state, and to bring those responsible to justice. But E.D. Rome laughs at him and says, ha, that's only the good old abduction thing. It adds nothing more to the existing crimes. If we get caught, we end up with just a few years behind bars, nothing serious. Plus, we escape the stigma. Well, E.D. Geneva says, still smiling. There in Geneva, some people say it may not just be that. In fact, some of them refer to your Rome statute of the ICC to argue that the law has changed and that now we should also prosecute at least certain types of non-state actors for enforced disappearances. Political organizations, for instance. Frightening, says E.D. Rome. Such inappropriate use of freedom of thought. Tell me if you need a hand to stop those people from thinking too much. I will, says E.D. Geneva. But unless they succeed, and we will see they don't, it's true you are safe, while we, as oppressive states, are very unpleasantly disturbed by the progress made by this convention. The definition of the crime in Article 2, you may have seen, is pretty straightforward and does not leave room for many doubts, save the state agency element we've just spoken about. Any form of deprivation of liberty followed by a refusal to acknowledge the deprivation of liberty or by concealment of the fate or whereabouts of the disappeared person, which place such a person outside the protection of the law. Well, interrupts E.D. Rome, I have heard that the last element you've just cited, this placement of the person outside the protection of the law, has happily been the victim of the negotiation process and was left in a state of, let's say, constructive ambiguity. Isn't that so? Doesn't it leave you some room of maneuver? Yes and no, Franz E.D. Geneva. Or little room, in fact. As I mentioned, this convention has an expert committee, and the committee has been loud and clear. States must give this element the status of a consequence of the deprivation of liberty. It may accept it has a circumstance of the crime, no more. Those who do differently oppose repeated and stubborn criticism from this committee. Expertise is a scourge, for sure, says E.D. Rome, apparently very concerned by that fact. Yes, it is, approves E.D. Geneva, also apparently very disturbed. The first thing we do, let's kill all the lawyers, as Shakespeare famously wrote in Henry VI. But the fact is that at the end of the day, you and your people from Kogan are safer under the ICC statutes. Am I? Says E.D. Rome with a sudden smile. Yes, E.D. Geneva goes on with envy. It's true the definition includes you as political organizations, but it is largely impracticable if it is to prosecute people, especially people like yourself. Why is that so? Says E.D. Rome with great excitement. Because it includes what lawyers call a specific intention. You're Roman, you should speak Latin. Dolo Specialist, can you get that? The deprivation of liberty and the refusal to acknowledge of give information must be done, I quote, with the intention of removing the persons from the protection of the law for a prolonged period of time. Are you joking? Says E.D. Rome with greater excitement. No, says E.D. Geneva, looking even more envious. It's almost too easy. You just disappear them for a short period of time and that's it. Well, says E.D. Rome, sometimes we need to keep them a bit longer, you see. Easy, almost shouts E.D. Geneva. You just lie on the date of the arrest. We do that all the time. Keep the person a month, but make it appear as 48 hours in the legal document. Oh, that's a beautiful idea, cries out E.D. Rome. Anyway, as E.D. Geneva, the prosecutor will have a hard time to prove the intent of each of your staff members who participated in the job. There has to be a sort of a common criminal purpose, you see. Good, says E.D. Rome with apparent satisfaction. A silence follows, and for a moment, both the head of Kogan and the chief of WUS seem lost in their thoughts. Then E.D. Rome suddenly raises his head and looks at his colleague. You're right, in fact, we criminal organizations are quite safe, and I've just been thinking, this ICC definition, it only applies if committed as a crime against humanity, meaning a part of a, quote, a widespread or systematic attack against a civilian population. That's true, says E.D. Geneva approvingly. And I've been thinking too, continues E.D. Rome, smiling, if I'm right, you states haven't settled so much tools for universal jurisdiction, judicial cooperation, legal assistance, extradition, all of those things, as far as crimes against humanity are concerned. So even if the other conditions were fulfilled, this would be another chance to get away with it, don't you think? It will suffice to reside in the right country at the right time, no? Yes, you're absolutely right, in fact. I missed that, says E.D. Geneva with some admiration. Although I must tell you that another group of experts, curse these, and also, in fact, a group of states, idiotic, sure, but equally sovereign to me, so I won't say more, are working on draft treaties precisely to fill a gap. Gosh, that's bad news, Franz E.D. Rome. Yes, terrible, says E.D. Geneva, but they are not yet there, I must say. And they are planning to adopt treaties, which is the most cumbersome and slow law-making technique. So I guess we'll still have some good days before us. Oh, this is only good cold comfort to me, says E.D. Rome. Don't be so pessimistic, says E.D. Geneva, tapping his friend's shoulder. If by chance one of these treaties is approved and then ratified by states, still it will apply to enforce disappearances as defined in the Rome Statute. Oh yes, You're a genius, cries out E.D. Rome, slapping his forehead and laughing. Another silence ensues, broken after a minute by E.D. Geneva. And, you know, I'm thinking about our situation of us, oppressive states in Geneva. When it comes to crimes against humanity, the convention is quite vague, in fact. It clearly leaves it to the ICC statute. At least it seems to have been the idea of the drafters. It only mentions this issue in 2 places. Article 5 is a kind of referencing clause stating that, I quote, "The widespread or systematic practice of enforced disappearances constitutes a crimes against humanity as defined in applicable international law and shall attract the consequences provided to under such applicable international law." And then Article 34 empowers the committee, curse the experts, to refer a situation of enforced disappearance as a crime against humanity to the General Assembly. "Are admirable," says E.D. Rome with a grin. "Yes," continues E.D. Geneva, "but what it means, I thought, is that we states are basically off the hook for crimes against humanity." "Are you really?" says E.D. Rome, waiting impatiently to know more. "Yes, indeed. It's true that, contrasting with the ICC statute, the Geneva Convention sets up quite elaborated obligation of cooperation, especially in its articles 13, 14, 15, and 25. But at least for those states who have ratified the ICC statute, these would apply only to enforced disappearances as a so-called autonomous crime, that is, not as a crime against humanity." "But how come?" says E.D. Rome, genuinely impressed. "Because most of those states have set up specific provisions to implement the ICC statute, including enforced disappearances, which are distinct from the provisions implementing the convention. That's the magic of what international lawyers are calling, I think, yes, the fragmentation of international law." "How beautiful," cries out E.D. Rome. "Yes, it is. The consequence is strange, although I must say, as the head of WOOS, I cannot but qualify it as positive." "And that is?" asks E.D. Rome. "We states, having ratified both the Geneva Convention and the Rome Statute, are better off committing enforced disappearances as part of a widespread attack against the civilian population than as an autonomous crime." "This is indeed surprising," says E.D. Rome, "but I guess you are exaggerating a bit. If the crime is in the code as an autonomous crime, they will get your people for this crime." "You're right," replies E.D. Geneva instantly, "but they won't get them for a crime against humanity. Isn't it better?" "Frankly, I don't know," says E.D. Rome, not completely convinced, "but this is troubling for sure." And after a short silence, he continues, "But I have another idea, and this one seems safe. Take armed conflicts, international or non-international." "Yes, and then what?" says E.D. Geneva, apparently lost. "Well, have you seen somewhere a war crime of enforced disappearance? Huh? Did you see it in Article 8 of the ICC statute, for instance? Come on." "Well, no," says E.D. Geneva, "but it's well known that enforced disappearances are prohibited under international customary law, which does apply to both international and non-international armed conflict. This is even written down in the compilation excellently produced by the RCRC, Rule 98, if you want to know." "Ha ha," laughs E.D. Rome, "but that's the magic of it. It is prohibited indeed, but there is no crime. No crime, no punishment. You want Latin? You get it. Nullum crimen sine lege." "Gosh, that's something," says E.D. Geneva, opening wide eyes. "So you mean if we commit enforced disappearances in connection with an armed conflict, though, continues E.D. Rome, not in the context of a widespread or systematic attack against the civilian population, that is equivalent to a crime against humanity, we get away with it," cries out E.D. Geneva. "Yes, we do," laughs E.D. Rome. "And we can work together on this. I like armed conflicts. It generally benefits a lot to our cooperation. Yes, it does, says ED Geneva. Let's drink to our benefits. Yes, cheers, says ED Rome. And so they went on all the night, sipping glasses of French champagne, paid on the account of the World War weapons providers, the WWWEEP, an organization that happens to be affiliated to both Woos and Kogan. According to the investigative journalist I have talked to, this is a very accurate transcription of what was said that day at this hotel in Nuremberg by ED Rome and ED Geneva. My submission is that it is always interesting to hear what the perpetrators have to say. They may be right on some point, they may be wrong on some others, either too pessimistic on their chances to be caught or too optimistic on their chances to get away with the crime. Still, this is a very enriching perspective for those who, like all of us today, are working in the opposite direction and striving as much as possible towards full accountability of the perpetrators of such a heinous crime as enforced disappearance. So what conclusions can we draw from what we heard? It seems that our two protagonists have identified contradictions, uncertainties, and even gaps in the normative framework against enforced disappearance. And they have shown that to a certain extent, these issues could be exploited at their advantage. What can we do to prevent this from happening? We could hear that most of the problems are coming from the fact that we have two definitions in international law which are not completely aligned. So we need to align them so as to come out with a definition that will be actionable and usable for the purpose of fighting against impunity in all contexts. A first issue we have heard comes from the Dolo Specialist, which has been added in the Rome definition, that is the definition of the Rome Statute of the International Criminal Court. On the one hand, the withdrawal from the protection of the law, which is normally a consequence of the deprivation of liberty, is defined in the Rome Statute as a special intent of the perpetrator. On the other hand, this Dolo Specialist adds a new temporal element to the crime by saying that the intention should be to withdraw the person from the protection of the law for a prolonged period of time. We have seen that our protagonists like this very much, because not only it adds an additional burden of proof for the prosecutor, but it may also allow in certain cases to cheat on the crime by falsifying the dates of the arrest and covering an enforced disappearance up into illegal detention. The big issue is that the Rome definition, the big issue we're facing now is that this Rome definition is more influential than, let's say, let's call it the Geneva definition. That is the definition contained in the Convention on Enforced Disappearances. 123 states parties to the ICC statute and only 63 states to the convention are parties to the convention. And a good number of states have already implemented the Rome Statute in their domestic legislations, including by transposing the crimes of the statute in their definitions in the criminal codes. Add to this that a number of statutes and treaties have taken as a model the Rome Statute. This is the case for a number of recent draft treaties, which are of concern. Our characters have alluded to two draft conventions, the International Law Commission's draft articles on crimes against humanity, and the more recent state-led initiative, the MLA initiative, standing for Mutual Legal Assistance Draft Convention. Those two texts are making copy-paste of the Rome definition, and despite the insistence of NGOs and some states, the drafters until now have refused to align the definition with the definition of the convention, but are copying and paste the definition of the Rome Statute. A first solution to that problem would be to amend the Rome Statute. but we know how complicated the procedure can be under Article 121 of the statute. So a safer way would be for the chambers to provide an interpretation of the existing provisions, which would be in line with the definition as provided in the convention. The domestic courts, of course, should also be encouraged to do the same when the crime has been incorporated in their domestic criminal codes. A push in the right direction came from the African Extraordinary Chamber in charge of judging Hissène Habré in Senegal. In its judgment dated of the 30th of May 2016, the Chambre d'Assises compared the two definitions of Rome and Geneva, concluded that there were differences between them, and then decided to go with the Geneva Convention definition, which, in its opinion, seemed to better reflect the state of international customary law, a conclusion with which I will, of course, agree. This was followed by another good move, a move in the right direction, coming this time from the ICC, and certainly would our protagonists have taken notice of it, it would have created a certain distress. In its decision pursuant to Article 15 of the Rome Statute on Burundi from 25 October 2017, Pre-Trial Chamber 3 of the ICC clearly facilitated the work of the prosecutor by stating the intention to remove the victim from the protection of the law could be inferred from the manner in which the person is deprived of his or her liberty. And it considered, for instance, a number of examples drawn from the case law of human rights bodies, like, for instance, the lack of a court order for the detention, abduction in cars without license plates and with tinted windows, detention in secret, unofficial prisons, etc. Still, commencing on the temporal element, the Chamber noted, and I quote, that the period of several months or years certainly fulfills the requirement of removal for a prolonged period of time. Whereas, as you know, the working group or the committee have often been faced in recent years, especially in the context of the fight against terrorism, with disappearances lasting only for a few days or a few weeks, the so-called short-term disappearances. The second issue we are facing, and which is also relating to the definition, has to do with the inclusion of non-state actors as potential perpetrators of enforced disappearances. The ICC statute clearly includes the so-called political organizations as perpetrators. But the convention takes a more ambiguous stand. Article 2, as very well summed up by our two characters, Article 2 includes a state agency element in the definition of enforced disappearances, whereas Article 3 sets obligation for the state to investigate and punish acts as defined in Article 2, committed by non-state actors acting without the authorization, support, or acquiescence of the state. Both the working group and the committee have and are still, in fact, carefully looking at this issue. It is worth noting in particular the bold move made by the working group in the now famous paragraph 94 of its 2019 annual report, where it stated, and I quote, "In light of its humanitarian mandate and the fact that the victims of these acts do not have any remedy to address their plight, the working group has decided to document cases concerning enforced or involuntary disappearances allegedly perpetrated by non-state actors that exercise effective control and/or government-like functions over a territory." The third issue identified during the conversation between ED Geneva and ED Rome deals with the consequences of the dual definition of enforced disappearances on the course of justice. And in particular, domestic procedures and procedures of judicial cooperation and judicial assistance between states. It may seem as a paradox, but in these fields, the ICC statutes does not offer much help. It is up to the states to provide for jurisdiction of their tribunals on the crimes of the court, including on the basis for instance, universal jurisdiction, which is so important, as we know. But some states pretend that the statute contains no obligation to do so. And it's because they have identified this gap, in fact, that some experts, and more recently some states, have proposed new treaties, and that's from where the ILC's articles on crimes against humanity and the MLA that I already mentioned come from. In the meantime, we find ourselves in strange situations where authors of enforced disappearances as a crime against humanity are better off than authors of enforced disappearances as an autonomous crime. At least this is, for instance, the case in France, where universal jurisdiction for crime against humanity is submitted to much tighter conditions than for enforced disappearances as an autonomous crime. This is just another argument in favor of the unification of the crime. If we want our tools of jurisdiction and cooperation to work properly and efficiently, we must have a single definition for a single crime: enforced disappearance, whatever the circumstance of the context. Finally, our two characters have identified a gap in international criminal law. Although enforced disappearances are prohibited under international humanitarian law, as it was very well reminded by one of the characters, there is no war crime of enforced disappearances, meaning that an enforced disappearance committed in connection with an armed conflict, but not in the context of a widespread or systematic attack against the civilian population, may not be punished as such. Of course, we must admit that it will certainly fall under other war crimes such as torture or unlawful confinement. It would thus seem appropriate to propose the recognition of a new war crime applicable to both international and non-international armed conflicts. Again, the possibility of amending the ICC statute could be looked at, but rather a declaration from an ICC judge that such a crime do exist in international customary law may be a more appropriate and a convenient way to proceed. In conclusion, I think there was no better place than this courtroom in Nuremberg to launch a call for a renewed effort and a renewed energy in fighting against impunity of perpetrators of enforced disappearances. Coming to an agreement on a unified definition of enforced disappearances will certainly be a step forward. Beyond, all states need to ratify the convention and cooperate so as to provide assistance to all victims and give effect to the victim's right to the truth, to reparation, and to justice. I would propose to name the Nuremberg call this idea of a renewed effort, a call which could be adopted by this conference today or tomorrow, with as an epigraph the words of the International Military Tribunal of Nuremberg, and I quote, "Crimes against international law are committed by men, not by abstract entities, and only by punishing individuals who commit such crimes can the provisions of international law be enforced." Thank you very much for your attention. And again, thank you very much for inviting me to give this address.